Broome. I know she was here. Sharon. Okay. Senator Broome has Senate Bill 73, Children Enacts the Uniform Child Abduction Prevention Act. This bill had been scheduled previously on the committee, and it was deferred by the author to give her the ability to draft some amendments. Ms. Broome, you want to go ahead?
Thank you, Mr. Chair, members of the committee. Based on some of the concern, I don't know if it was last week or week before last, when I was here discussing Senate Bill 73, I decided to take a closer look, revisit it, and certainly take into consideration some of the comments that were made by committee members. Since then, I've had some discussions with several individuals. I do have some amendments, but if you indulge me very briefly, because I have to get to another committee meeting as well, so I understand time constraints here. But with me today is Mr. Trish from the law, Attorney Trish from the Law Institute, who perhaps can bring some additional information as it relates to this legislation and the famous commissioners that we talked about last week who were behind this legislation. So if he'd make some comments, and then, Mr. Chair, we could talk about the amendments, or perhaps it will elevate the comfort level of many of the members as it relates to the legislation as it is.
Okay, Mr. Trish.
Yeah.
Who is this group that you're talking about?
Well, I work for the Law Institute, but I'm not here representing the Law Institute. This is the National Commission on Uniform State Laws, of which the chairman is also a member. There are about 5 or 6 members from Louisiana. And this organization, NACUSL, is an organization very similar to the Law Institute. They have committee meetings, and they discuss legislation, and then they have an annual meeting where the whole country gets together and all the representatives look over. It's a very long, deliberative process where they take input from the American Bar Association, all the various special interest groups throughout the country. So they don't undertake projects unless there's a big need for it. And there is a big need for this type of legislation because of the number of child abductions that take place in this country. And a lot of them are international. You read about those cases all the time, but most of them happen within the United States. And what this act is designed to do is to give all states the same legal mechanism, so that if a child is abducted in a child custody case, then all the states will be on the same page and will follow all the same laws and procedures. And it's not we have some of these type of protections in Louisiana already, so this is not a real big change in the law. You can go get a bond to enforce visitation rights. We have that here, and this allows it too. So the fact that we have remedies already, it's not an argument that we shouldn't adopt this. It's actually an argument that we should adopt it. But actually the remedies we have aren't sufficient. We have kidnapping laws, we have child protection laws and things like that, but this is designed to prevent the abduction from ever taking place. The laws that we have on the books now are mostly reactive. After a parent has taken a child and moved away, you can charge them with kidnapping. But here it's designed to do it. Now there's a lot of concern about, well, if you change your lease, that's grounds to do it. But the arguments essentially are arguments saying that we have bad judges, and so we shouldn't pass this law because some judges might misapply it. But I don't know how many judges are going to allow one of these orders to issue simply because someone changes a lease or gets a passport. That's just one piece of evidence. They're going to want to hear all of the evidence, and then they're going to decide if there is a credible risk that this child may be taken away.
Mr. Trish, can you show us where in the bill is the language that would seem to prevent a parent from abducting the child prior to an order? This gives the parent an opportunity to go to court if they suspect that the other parent might want to remove the child from the state?
Exactly. They go.
Do we have a way to do that right now under our existing law?
There's no procedure that details this. I think you can go into court and ask for any relief possible, but there's not a statute that gives you the whole process about have the hearing, the notice to the other side.
Okay, show us where that is in the bill.
Okay.
Page 4 and 5, I believe.
A petition, yeah, it starts off with actually contents of the petition. Well, on page 3 and the top of page 4, it tells you about the petition and that you file that starts the whole process. And the petition has to specify the risk factors of abduction, et cetera, and it also has to include all the other information that you see on lines 6 down to 17, such as a statement whether there's a prior action to prevent abduction is filed, and those things have to be in the petition. And then you have on page, in the hearing, page 6, I'm looking at line 25, in the hearing on the petition of this part, what the court is to consider. And they are to consider whether the conduct's necessary to imminent harm to the child or other evidence may be relevant. So, I mean, there's, throughout here, there are procedures that you follow. I mean, that's what the whole act is about.
Okay.
Is about.
All right, thank you. I mean, so we're setting up like a procedure, an independent cause, or giving the right of a parent to file a petition on its own, alleging these various things, and allowing them the opportunity to seek an order to the court that the child can't be removed. Is that right?
Right.
Okay. Now, when you talk about other states, do you know how many other states have adopted something similar to this?
I'm sorry, I didn't.
I had
you
the
might have
update. I had the
latest.
update from last week, and I think it hasn't changed. Let's see. There are 1, 2, 3, 4. I think 5 states now. I got a recent update that have enacted it.
Right, but it's been introduced by a lot, and you know, usually with these bills, it takes a little while as each session goes through with each state. But the idea is to get all 50 states on board, just as we have with the Uniform Child Support, Uniform Child Custody Acts. It takes a little while, but eventually, we're hoping all the states will adopt this.
Okay. Ms. Bowe, you have your questions now, or would you prefer after we put the amendments on, or? Well, I don't know. Would you like your questions now before the amendments are proposed? Okay. You offer up the amendments for adoption? Who can explain the amendments? Who worked them on staff? You can? Go ahead, Ms. Bowe.
Basically, what the amendments do is take it out of, take all the state-to-state stuff out of it and strictly limit the bill to the potential international abduction. And I think it even further limits it to only to those countries that we wouldn't have, I wanted to say Geneva Agreement, that's the wrong one.
Can you read the amendment?
Well, rather than me read through the amendments, I would rather listen to Carol's melodious voice.
Okay.
Read through them, because it makes the same change throughout. The only other change that's not necessarily part of the, actually there are 2 that are not part of that international thing, is on page 4, line 20, where the introductory paragraph where factors to determine risk of abduction, we're going to say that the court shall consider all of the following facts and any evidence. So he has to actually review all of those to see what the answers are.
Correct.
Must weigh every one of them. So if he's abandoned his deployment, but he's never threatened to abduct the child,
Right.
then both of those things have to enter into that consideration. And I think there was something at the end.
You discussed these, Ms. Broome, with Ms. Bowler?
These are
These are your amendments?
I
Okay.
discussed
These are
them with-
Bowler,
yeah.
Broome amendments?
Yeah.
Wonderful.
What a partnership.
Wonderful.
Here we go. And I think Ms. Braun did the drafting.
That sends a loud signal.
And the only other thing I think is a technical amendment that we really should adopt, whether we go for the international stuff or not, and that's on page 11. We're taking an "or" out of line 2. That was just unnecessary.
Okay. Cal, you need to read them, or does anyone
To the
understand?
record. You know, to the record.
Put your microphone down.
The members you've previously adopted a set marked 2576, and these are 3292. All the members have it, and Representative Bowler described them exactly what these amendments do.
Okay. All right. Does anyone have any questions on the amendments? Any questions? Ms. Bowler offers up a set of amendments which have been explained. Does anyone have any objection to the adoption of the amendments? Any objection? Hearing no objection, the amendments are adopted. The board is clear. Ms. Broome, would you like to close?
Well, let me just say that I would be remiss if I didn't say that we still have a statewide...
I'm sorry.
I'm sorry.
I'm sorry. I recognize you for closing when I do have cards in opposition.
Oh, okay.
Okay, let me just read them. Norris Jens with Louisiana Dads is opposed, would not like to speak. Carrie, you filled out a card in opposition.
Oh, I'm sorry. Put that in your scrapbook.
Dr. Norman Dale Norris in opposition would like to speak. Dr. Norris, is he here? Come on to the table. And Mr. Nicholas James with Louisiana Dads would like to speak.
Are you opposed with the amendments on it? Yes. Did you just hear us discuss it?
Yes, could we look at them? Do you have
Sure.
do you have a printed, do we have a few minutes to look through the revised bill?
Yeah. Basically, all they do is change the whole focus to international.
With hate states, or say non-hate states?
Yes.
Okay. Is there a copy of the bill here?
While they're looking at the bill, Ms. Mosley, would you explain to these gentlemen what the amendments do again?
14.
Pull your mic down.
You go ahead. Mr. Singletary.
Okay.
International, okay.
The amendments, as Representative Bowler explained, simply make the bill apply internationally instead of within the United States, except for a couple of amendments, that being Amendment Number 4, which dealt with the consideration of all the factors and evidence, and a technical amendment, which was Amendment Number 14, I'm sorry, which removed an unnecessary "or." But the remainder of the amendments just go through the bill and remove references to state and, anything that would make it apply within the states.
Okay. I'm sorry?
There was a threat of an international abduction.
Okay. So you're okay. I'm still arrested. I'm a first-generation American, by the way. My family came from England. My grandparents, my uncles and aunts all still live in England, so...
So it still affects you.
Yeah. In fact, my boss just said I've got to make travel reservations for a convention in England in November, so it could still potentially affect me. But by taking the state, one of the biggest objections was the state part. So if the state part is removed, that is a substantial part of our objection to this bill.
Okay, might I pose a question as well? Am I understanding correctly that with this list of criteria that the judge can look at, did I understand, Mrs. Bowler, that every one of those things must be in place before the judge? Every one of them, not
Okay.
Would y'all like to confer a little bit? Maybe I can take it.
Sure, could we do that?
No? Okay.
Okay.
No, we got to keep going.
Got to keep going. Let's see. The only other part we might want some modification would be the part on the exigent circumstances. And I'm not sure what section that's in. If someone can help me find that. Warrant to take physical care. That's 1859. Sure, go ahead.
Mr. Chair, I don't want to delay your committee. I will give these gentlemen, since the major objection that they had was the state-to-state issue, if they would allow me to go ahead and pass the bill, and those, I think the issue that you're talking about is something that we can possibly
I think what we need to do would be to approve the bill, let the staff re-engross it, so it's reprinted, and then we could read it with some degree of understanding. And if you have the authors...
An unofficial reimbursement.
What?
Okay.
I'm sorry, we can do an unofficial re-engrossment, but it won't be re-engrossed. Since it's a Senate bill, we won't be putting the...
Oh, they do things differently.
Well, we don't
we do things correctly.
Right.
Right.
Yeah.
Well,
Thank you.
as long as you pass my bill, it doesn't matter who does it, which way.
We can do an unofficial reengrossment of it.
And then we can read it with some degree of hope and understand it.
Would that allow me to pass the bill?
Yeah, it's going to come, you know.
Okay, I'm not sure which page I'm
Mr.
on.
James still was opposed, but he didn't have a vote on the committee.
Right. I never get
I
a
do have
vote.
another.
We don't have page numbers on our copy. Do you have a copy with page numbers on? I mean, section. Here we go.
And I have all the amendments written out there, so we can talk about it afterwards.
Page 9.
Okay. The F. Okay, it's section 1859, warrant to take physical custody of the child. Section F. A warrant to take physical custody of the child issued by this state or another state is enforceable throughout this state. If the court finds that a less intrusive remedy will not be effective, it may authorize law enforcement officers to enter private property to take physical custody of the child. If required by exigent circumstances, the court may authorize law enforcement officers to make a forcible entry at any hour. I was wanting some additional checks in there. The court on its own motion can issue the order that triggers all of this. So would it be possible to get it so that a judge, if he is the person issuing the ex parte motion, that he has to get it signed off by a second judge before the
That's not a normal process.
exigent circumstances could be triggered?
But that's not a normal process.
Now, you want a judge to judge a judge.
Well, if the judge is if
If the judge is the plaintiff,
the judge,
he's not going to be the judge presiding over the case.
right, that's what we want to make sure of in that.
Oh, I can assure you that, and our rules, our regular rules of procedure, and our rules of recusal, and what have you, and a judge's rules of conduct that govern the judiciary would not allow for anything like that.
Okay, because right now as written, it does allow the judge to be the issuing party for the petition.
But not if he's the petitioner.
Right. So if he's the petitioner and he's recused under the existing rules, so that
Right.
a second judge and a third party has to sign off on it for the no-knock warrant, that would be.
I will assure you that our existing, there are a number of different rules that would take care of that situation.
Thank you.
Okay, Ms. Bowler moves that the amendments be adopted. Is there any objection to the adoption of the amendment? Any objection? Hearing no objection, the amendments are adopted. Mr. Johns moves that Senate Bill 73 be reported with amendments. Is there any objection to that motion? Hearing no objection, 73 is reported
Thank
with
you.
amendments. Senator Mount?
Thank you, Mr. Chair, members.
You're welcome. Senator Mount has Senate Bill 208, provides for the appointment and duties